Okay, my name's Jeff Sheldon. Thank you for coming. I'm going to be talking about protecting ideas and avoiding infringement. This is principally for people interested in bringing a new product or process or method to market or trying to license their ideas and try to make money from it. So we'll get right into it. The general approach we're going to use is I'm going to be talking for 50 minutes, 55 minutes. We'll take a break and then I'll answer all the questions. But please save the questions for the end. My experience generally is a lot of the questions I'll eventually get to just in the presentation. So just keep things moving right along. But everybody will get a chance to ask whatever questions they have. Under U.S. law, the starting point is everything can be copied. So anything you see in the marketplace, any new idea you have, any new product you come out with, there is no protection. Anybody can go out and duplicate the same thing, unless you fall in one of the exceptions. And there are multiple exceptions. You can get a utility patent, a design patent, copyright, trademarks and trade dress, and contractual rights. Those are the various different ways of getting protection. You need to fall in one of those exceptions. If you can get into one of those exceptions, you may be able to protect the idea or your invention, and we're going to cover all of those. The contrary position is if somebody else has a utility patent, a design patent, a trade secret, a copyright, a trademark, trade dress, or contractual rights against you, you may not be able to copy their ideas. So this works both ways, protection and vulnerability to a lawsuit. I'm showing you a product called the Entail lamp. You might ask why. Well, our firm was involved in a lawsuit a long time ago involving that. But this is an example of a product with multiple types of protection. So one theme is there are multiple ways to skin the cat. There's multiple ways to protect a product. An example, in the Entail lamp, they had a design patent, a utility patent. They were claiming trade dress rights and copyright rights. And all of those were available against the defendant. So let's talk about utility patent. I'm going to cover what is a patent, why you bother obtaining one, what are the legal requirements for patents, who owns the patent, what is infringement, and how can you avoid infringement. I'm going to give you an example of a patented product. I'm kind of proud of this one because this has been a successful product that our firms help get patents around the world on. And it's something called InStyler. It's for styling hair. But that's an example of a utility patented product. But like the Entail lamp, it has other protection. It has trade dress protection, also has trademark protection. It has design patent protection. The packaging has copyright protection. So to the extent there's counterfeiters out there, and there generally are when you have a successful commercial product for the retail trade, you need multiple ways to put a stop to it. So why do you seek a patent? I'm giving you a hint. See the big dollar sign? That's why most people want a patent. There's multiple reasons. One is defensive. Some people just get a patent to get the or apply for a patent to get the application published, and it becomes prior art. It's defensive. It gets in the way of other people trying to get a patent. The main reasons are offensive. If you have a patent, you have the exclusive right to your invention. It helps protect market share. It protects profit margins. It's a licensing vehicle, and you get patent pending. Now, you know one thing I did not say. I did not say you need a patent to sell your product. You don't. A patent is really a right to exclude. It keeps other people from using your invention. Imagine you're back in Prohibition, and you came out with a better way of making rum, and you've got a patent on it. The U.S. Patent Office would have issued a patent for it. But what can you do with that? Nothing. It's illegal to manufacture and sell rum during Prohibition. Often, drug companies come up with ideas for new drugs, and they'll immediately file patent applications. But without FDA approval, the patent's worthless because they can't sell the product. So when somebody comes to me and says they need a patent to sell the product, I say, first, no, you don't. And then the second question I ask is, can you make money from your invention? Because if you can't sell your product at a profit, nobody's going to copy it anyway. So why bother getting a patent? The patent's really only as good as the commercial value of the underlying invention. And there are some marketing benefits. It provides a little bit of pizzazz to be able to say my product is patented. Some consumers and industrial people will say, well, that must mean it's valuable, it has some benefits, and it helps make sales. Another reason is prestige. There's a lot of companies that like to represent themselves as being technically forward. Apple, Hewlett-Packard, IBM. So they get a lot of patents, and it adds to the prestige. And the last, which is sort of a silly reason, but we need to recognize it, is ego. I mean, I've had clients come in with what I said was a dumb idea, and I say, you know, you think you really can make money from this? And they said, no, I know I can't, but I want that patent. I want a plaque. I want it behind my desk so people think I'm smart. Okay? Well, that's not my call, but it's a reality. Okay, what are the requirements for a patent? And now we're talking U.S. law, but they're similar around the world. First of all, you have to have what we call statutory subject matter. There's certain things that can't be patented. The things that can be are processes, articles of manufacture, machines, compositions of matter. If you looked around this room, the types of things we see utility patents are just this little laptop of mine probably has thousands of patents. Maybe the method of making the bottled water, the material for the table. But certain things can't be patented, like abstract ideas, laws of nature. You can't patent gravity. You may discover it, like Newton did, but you can't get a patent on it. Works of art, paintings, books, those type of things are not statutory subject matter. They're not subject of a utility patent. It has to work. It has to be operable. Now you ask, who would try to patent something where you don't know it'll work? Well, I've had people come in with a wonderful invention. They say, I got this pendulum, and I do this, and I do that, and at the end of the day, I'm going to get more energy out than I put in. Well, if any of you have studied thermodynamics, you know that's impossible. Second law of thermodynamics says you can't get more energy out than you put in. That's a perpetual motion machine. Now, I don't like to tell people you're dumb. That doesn't do well for client relations. So what I tell them, and this is the truth, the patent office always has the option of saying, I don't believe you. Prove this actually works. So I tell them, well, you know what? The patent office is probably going to ask us to prove your perpetual motion machine works. Why don't you go off to U.S. testing labs, run some tests, get me that data, and then we'll file the application. And that's the last I hear from them. Because U.S. testing labs says, no, of course not. In areas where utility has been questioned in the past were cures for baldness. Well, technology's caught up with the skepticism of the patent office. We know that, I don't know if you call it a cure, but you got Rogaine out there. Similarly with cancer, 75 years ago, if you came to me with a cancer cure, the patent attorney would laugh, say, the patent office is not going to buy it, prove it works. Well, now we know there are cures for cancer. Correct inventorship. Under U.S. law, only the inventors can apply for a patent. So if you go off to Germany and find a better potato peeler that's not in the market in the U.S., a better, let's assume it meets all the other requirements for a patent, you can't get the patent because you're not the inventor. Only the inventor can apply for the patent. Novelty. It's got to be new. Nobody can ever have done the same thing before. Now, Article 1, Section 8 of the Constitution is the basis for patents, and the basic deal is, in the Constitution, the inventor contributes something the public doesn't have. In exchange for that, you're going to get exclusive rights for a limited period of time. But if the public already has it, then you can't get a patent. There's no tit for tat. Where's the deal? And this novelty requirement is pretty tough. For example, if there's a PhD thesis in a library and it's accessible in Outer Mongolia, written in Mongolian, if that's a language, that is prior art, and if that teaches your invention, you're out of luck, even though nobody in the United States has ever seen it. As long as the information is publicly available, and it's the same as what you're trying to patent, you're going to fail the novelty requirement. No statutory bar. This has nothing to do with drinking. Statutory bar it's called that because there's a bar against getting a patent that's in the patent statute. So it's called statutory bar. And basically it says if your invention has been publicly known or on sale for more than 1 year before you file your application, you're out of luck. It's too late. And notice I said on sale, not sold. So if you go to General Motors and say, hey, I've got a better windshield wiper, are you interested in buying it? I'll sell you 100 of them for $1 each. That starts the clock ticking. That's when the 1 year starts. And they may say, forget it, we're not going to buy it. It doesn't matter. You offered it for sale. So you need to be aware of that. Now, Interestingly, if you're interested in foreign protection, the U.S. statutory bar is actually pretty liberal. That's a 1-year grace period. Most foreign countries don't have that. So if you're interested in foreign patent protection, the recommendation is file right away before you do anything commercial or do anything making it available to the public. And the last requirement is non-obviousness. The invention has to be non-obvious to a person of ordinary skill in the art. It's what I call the gee whiz test. There's a lot of different ways to express it, but basically if you go to somebody who's knowledgeable in the field and you tell them your idea and they say, gee whiz, I wish I thought of that, you may have something that's non-obvious. And that's where we spend most of the time fighting with the patent office. Is it obvious to do this or do that in view of what other people have already done? Here's a nice example of lack of novelty. We've got our guy going off to the patent office, invented the wheel, but unfortunately somebody already invented roller skates. So no novelty, you're out of luck. Okay, should you seek a patent? If you want, I have a handout that's available. It's from a chapter of a book I'm writing, and basically it provides a checklist as to whether or not you should file a patent application. And does your invention meet the legal standards, and does it make business sense? And we also have another brochure, if you want it. It takes you through the basic process of patenting inventions. So if you're interested, we can make that available.